Hello everyone, and welcome to NCVO Bond and Bateswell's webinar on General Election 2019 Campaigning and Election Law. My name is Douglas Dowell. I'm Policy Manager at NCVO.
Stacey Frier, Policy Advisor at Bond.
Suhan Rajkumar, Associate in the Charity and Social Enterprise team at Bateswells.
Okay. So I'm going to give you a bit of a rundown on what we're going to cover very shortly, but we're going to start by getting a sense of how confident you all feel at the moment about campaigning over this period. So we'll start with a poll. You'll get some options coming up, and if you can cast your vote when you see them. We're asking you how confident you feel about campaigning at the moment with the current rules. So while you're voting and considering, we're going to talk a bit about charity law and some of the key requirements upon charities, especially in an electoral context. We're also going to talk distinctly about electoral law, both the statute and the guidance, and a bit about what's changed in the guidance recently as well, because there have been some really useful and reassuring changes in the past couple of months. And we'll also talk a little bit about compliance and how some organisations actually manage some of these requirements as well. So we're hoping it'll be practical and useful. I should let you know as well that if you look on the right-hand side, you will see a little question mark that you can click on. That's how you sort of queue up questions which you type in. And we'll take all questions at the end, but you can write questions in as you go, and we will try to answer as many as we can in the final 15 minutes of the webinar as well. Okay, so just waiting for the results to come up. Okay, so it looks like we've got a reasonably confident audience here, but I'm hoping that for the 22% of you, we'll be able to help you out a little bit and leave you a little more confidently when you started. And if we can get some of you up from reasonably to very, that would be all to the good as well. So without further ado, I'm going to hand over to Suhan to start us off.
Great, thank you, Douglas. So we're going to cover quite a lot of ground today. We're going to go through firstly the charity law background for charities campaigning or carrying out political activity ahead of an election. And so that's charity law and also the Charity Commission's guidance, CC9, and charities, elections and referendums. Obviously that will only be applicable to those of you who are representing registered charities. And then we'll cover the electoral law framework, which is set out in two pieces of legislation, the Political Parties, Elections and Referendums Act and the Representation of the People Act. Once we've gone through that background, we'll talk through how that, what implications all of those legal frameworks have for you. So, charity law. Hopefully you are all reasonably confident with the charity law background, but I think it's really important just to set out the framework because it does impact the application of electoral law as well. As you know, a charity must be established for charitable purposes only, and a purpose won't be charitable if it's solely political. However, you can, as charities, of course, campaign and undertake political activity if it supports your delivery of your charitable purposes. So you and your trustees should always be thinking about a campaigning activity or political activity is furthering your charitable purposes. It can't be party political, it can't be your sole or continuing activity, but you can absolutely campaign and carry out political activity. Building out on that basic charity law requirement, the Charity Commission has some helpful guidance, CC9, which applies to charities campaigning generally. This guidance is really useful to guide you through the questions you should be asking yourselves if you're a registered charity when you're thinking about carrying out campaigning or political activity. Does this activity further our charitable objects? And if so, how likely is it that it will help us achieve our objective? Does it involve a reasonable use of our resources, as you should be asking for any charitable activity? And again, what are the risks, both in relation to your charitable purposes and to all sorts of other legal duties? CC9 is quite high level, and the Charity Commission has also released some much more granular guidance, which applies specifically from the announcement of an election until the date of the election. So that's in force now. CC9 covers charities supporting policies, charities releasing publicity, and support of parties and candidates. The first rule for any charity is that you must never support a party or candidate or make a donation to a party or candidate. This can get a bit tricky where a charity's policy position aligns with the policy position of a party or candidate. The Charity Commission's guidance recognises that it's absolutely fine to continue campaigning on an issue where you have a policy position and advocate for the charity's position, as long as you maintain and stress your independence. You must also take steps to manage the risk of perception of alignment with a party political position. So it's not just about what you're intending to do, but also how your actions are perceived. This is also really important for the publicity that a charity carries out. You must never make a call to voters or attempt to influence voter behaviour, and again, you must never support a party or candidate. However, it is possible to make clear your policy goals and achieve that effect by other means. The Commission has some really helpful guidance which says that if you, for example, support the opening of 1,000 new libraries, while you can't say our policy is X and each of the political parties' policy is Y, you can just compare the political parties' policies and leave it to the viewer to make up their own mind about how to vote or what policy to align themselves with. You can also, of course, publish a manifesto in order to publicise the charity's core issues, and this can be a great way of achieving your charitable objectives or furthering them. However, this isn't acceptable where the intention is to influence voter behaviour. One more time, you must never support a party or candidate. That's the key point from charity law. And again, while that might seem obvious, there are some instances where it can become a bit complex. If you're, for example, organising a hustings, as many charities do, inviting local candidates or representatives of the national parties to discuss an issue which is core to your charity's objectives, you need to think about avoiding that being seen as endorsing or supporting a particular party or candidate. So it wouldn't be right, for example, to only invite parties who are broadly aligned with your position, unless you have another reasonable and objective reason for not inviting the other parties. The final risk that I wanted to flag in relation to charity law is social media. As I'm sure you're all aware, the Charity Commission can be very concerned with publicity and media attention. And indeed, in the 2015 election, released a report into a charity where the Commission was particularly critical of the charity's use of social media. So this is just a reminder that as well as your actual campaigning activity and thinking about how that fits into charitable law, you should think about both your social media accounts, which might be run a little more informally, and your employees and volunteers' social media accounts. You should be asking your employees, volunteers and trustees to make sure that their social media say views my own or similar, and that they're not representing the charity when they're sharing their personal political views.
Thank you, Suhan. So we're going to move on to electoral law now, having given you a bit of an overview of charity law. And before we start, I'd be interested to see how many of you are thinking specifically about electoral law. So we're going to start with another poll, which is a chance for you to let us know whether you either have or are planning to register with the Electoral Commission. So you can cast your vote now. In the meantime, Stacey, is this something that you've had much of a sense of members doing?
I was perhaps not our members, but I certainly know there are a couple of organisations that will be signing up as registering, but I don't think lots of people will be. So it'll be interesting to see what the answer is to this poll.
Yes, no, we're waiting with bated breath over here. Is it something that you've seen much of, Suhan?
Yeah, I think a couple of charities and non-party campaigners that we work with have been thinking about whether to register. And I think hopefully we can give you some clarity on when you need to, because I think that's something that isn't clear to a lot of people.
Yeah, I think our experience so far has been more commonly people who are thinking about it, but have concluded they didn't need to. So looking, it looks like our our anecdotal experience so far is matching up, and that most of you are saying you're not planning to, and about 10% of you are saying yes. It'll be interesting to see whether or not this sort of helps you and gives you some more clarity as to whether you actually need to or not. But we'll talk through a bit about the electoral law side of things now, both in terms of the statute and the guidance. Okay, so at this point, I'm going to hand over to Suhan to start with the main election law regimes.
Great, thanks. So as I mentioned earlier, there are two main pieces of legislation which implement legal frameworks around campaigning ahead of an election for non-party campaigners. These are split into general campaigns and local campaigns. Local campaigning is governed by the Representation of the People Act 1983 and governs activity or expenditure which is intended to promote or procure the electoral success of a particular candidate in a constituency. The effect of the RPA is to effectively ban all spending that is intended to promote the success of a particular candidate, unless you are that candidate or authorised by them, subject to an exception of £700, which is quite low. It applies from the dissolution of Parliament, so that was the 6th of November, until the date of the election. However, as I was keen to stress earlier, if you're a charity, you obviously can't support a particular candidate or party, and therefore as charities, we think it would be really unlikely that you would engage this prohibition. It might be a bit more complex for non-party campaigners, and that is something that you should be thinking about. PPERA is the other piece of legislation, the Political Parties, Elections and Referendums Act 2000. This governs general campaigning, which it defines really quite broadly as campaigning which is for or against a political party, policy, issue, or candidates who are aligned because of a policy or issue. This has a much wider regulated period as well, which we'll come on to now, and is regulated by the Electoral Commission. It's under PPERA that you might have to register with the Electoral Commission. So we'll go into some more detail on PPERA because I think that will be most relevant to the charities amongst you. PPERA was introduced in 2000 after a number of political funding scandals to give transparency on donations in political parties. However, until 2014, because of particularly high spending limits and some carve-outs for non-party campaigners, it wasn't hugely relevant to non-party campaigners. In 2014, the Lobbying Act significantly widened the scope of PPERA, and for that reason, the PPERA regime is often known among non-party campaigners as the Lobbying Act. The effect of PPERA is to create a framework which involves registration with the Electoral Commission and then imposes a number of spending and donation controls and reporting requirements on registered entities.
So spending limits are obviously a key part of the electoral law side of things for charities and indeed for non-party campaigners as a whole. It's a bit of a gateway condition in that I think one thing to understand about electoral law is that whereas quite a lot of charity law is about what you can and can't do, for us electoral law is more commonly about how much you can spend on certain kinds of activities. So there are two issues here. The first is how much you need to spend on regulated activity before you have to register with the Commission. And the other issue is how much you are allowed to spend once you are registered. Now, you only need to register with the Electoral Commission if over the regulated period you are spending more than £20,000 on regulated activity in England, or more than £10,000 in any one of Scotland, Wales or Northern Ireland. So if you know your total campaign spending, including staff costs, definitely won't breach those limits over that period, then you already know that you don't need to register with the Commission. I will just say, don't forget constituency limits. A UK general election has limits on how much can be spent in any one parliamentary constituency. Suhan's going to talk a little bit more about how that is defined. It probably isn't an issue for most charities, but that is a question of something you cannot do rather than something you need to register for. If you are registered, you can spend more money on regulated activity. Suhan's going to talk a bit more about those limits and we'll also give you, what those limits are as well.
Great, thanks Douglas. So you're probably wondering two questions now when you're trying to work out whether you have to register with the Electoral Commission. Firstly, what exactly is regulated activity and how do I identify it? And over what period do I have to look to identify that regulated activity? For non-party campaigners, the regulated period is set out in the legislation. It differs for each type of election, but for a general election, it's the 12 months preceding the election. So in this case, that's from the 13th of December until the election date. And as you're probably aware, that period can be retrospective. We didn't know on the 13th of December last year that there was going to be an election.
So at this point, we're going to take another poll, because this is an issue which has obviously been discussed fairly extensively, actually, with the 2017 general election and the European elections earlier this year. Are you worried about the retrospective regulated period? Is this something you're thinking about? So as I say, I mean, it's been a conversation we've had to have a number of times, really, one way or another, but we're hoping that we can give you a bit more of the information about it, but also a bit more of the reassurance, because there has been some quite emphatic reassurance from the Electoral Commission on how this operates. Is it something that you've heard sort of raised, Suhan?
Yeah, definitely. So I remember when the Lobbying Act came in, there was a big conversation about it having a real chilling effect on charities and non-party campaigners. And we've definitely had questions from clients recently, once the election was announced, wondering, does this mean I have to look at all of my activity for the past year?
Yeah. So back to C. Okay, good. We've got a confident webinar audience in that case. Well, glad to see that 80% of you or so aren't worried. We hope to assuage some of the fears of the 19%. On which note, I'm shortly going to hand back to Suhan to talk a bit about the issue as it's been raised.
Thanks, Douglas. So, as Douglas mentioned, this isn't the first time that the retrospectivity of the regulated period has been an issue. As you'll remember, in 2017, there was absolutely not going to be an election. Emphatically, Theresa May was not calling an election until suddenly we were going to have one. We've had the same this year, where in August, early September, we were promised there would absolutely be no election. All the parties were voting against an election. And now that the election has been called for the 12th of December, the regulated period stretches back for a year. But that doesn't mean that you have to look back at all of your activity during that year, and Douglas is going to explain why.
Indeed I am. So it is a snap election, as they're called, but the Electoral Commission has made it very clear that it will take that fact into account. Now, we know it was a matter that concerned a number of campaigners in 2017, and the Commission tried to give some reassurance then as well, and they're being a lot clearer this time round. So first of all, in the guidance, the Commission points out that obviously many campaigns are issue-based rather than focusing on candidates or parties, and that would make it less likely that they met the purpose test in any event. And for charities and for NGOs, I think that's a particularly relevant point anyway. But more than that, and this has always been NCVO's view, the Commission is basically saying that you are unlikely to be reasonably regarded as intending to influence voting in an election when you don't know or expect that an election is happening. And this is common sense, really. It is pretty hard to be trying to influence an election you have no idea about. So in its general election guidance for this year, the Commission says that most campaign activity before the election was announced is unlikely to meet the purpose test. There are two main exceptions to bear in mind, I think. The first is, do remember that the purpose test covers activity reasonably regarded as intending to influence other elections during the regulated period, not just the general election in this case. So this time round, we'd be thinking about any activity which met the purpose test for the European elections in late May this year, and the local elections in early May this year. And activity which met the purpose test for those elections could be regulated activity. Secondly, if you made reference to the election before it was announced in your campaigning activity, that makes it a little more likely to meet the purpose test. This may well be somewhat less likely to affect charities, and the Commission's examples, as you can see on the slide, are pretty clearly party political. There may be some nuance just because there's been slightly more awareness that an election might be coming up this time round, but nonetheless the overall message is that for the most part, from a charity point of view, activity carried out before the election was announced is unlikely to be in purpose test territory.
Absolutely. So I think where some of that nuance might come into play is if you think about your campaigning activity kind of around early September, where an election hadn't been announced, but at around that point, it became clear that we were going to have an election within the next couple of months. And whether you're campaigning at that stage might have slightly changed in its tone, might have said things like, we need a government which will do X. That's when you might want to start thinking about, actually, although we didn't know there was going to be an election, did that campaigning envisage an election and therefore pass the purpose test? So just to recap, before we go into the detail of what the purpose test is and how you assess whether your activity is regulated, you don't need to worry about registration if you spend if you're going to spend less than £20,000 in England or less than £10,000 in any of Scotland, Wales or Northern Ireland. If you know that your whole campaign budget is less than those numbers, then although you still have to think about charity law and a couple of other compliance requirements, which we'll come on to later, you don't need to worry about registering with the Electoral Commission. If you do choose to register with the Electoral Commission because you know that you are, or you are concerned that you are going to hit those thresholds, then it was really reassuring to see earlier that none of you have not yet registered but are planning to, because you are supposed to do that as soon as possible once you are aware that the election is happening and that you're going to meet those thresholds. So there is still time, but it would be good to do that as soon as possible if you think that it might be the case. And once you're registered, there are additional administrative burdens which involve keeping invoices, tracking spending, reporting your spending, and checking the donations that you receive and ensuring that they're compliant with electoral law. We'll come on to the detail of those later, but it's also worth thinking about the pros which come with registering with the Electoral Commission, which are that you have access to significantly higher spending limits. For a normal general election, those would be about £320,000 in England and lower figures in Scotland, Wales and Northern Ireland. At this election, because we also had the European elections earlier this year, the spending limits for that election are rolled up into the spending limits for this election because of the effect of that 12-month period. And so in that case, you can spend on a UK-wide campaign £585,000 across the UK, or in each constituent part of the UK, the figures that are on your screen. Those are not the only spending limits to consider, unfortunately. There are also limits on targeted spending and constituency spending. The targeted spending rules apply if your campaign can be reasonably regarded as intended to influence voters to vote for one particular party or any of its candidates and no other party. Generally, we wouldn't expect that to capture charities or, to be honest, most non-party campaigners, because you'll be looking at issue-based campaigns. And if you're a charity, you can't support a particular political party or candidate. It's designed to catch organisations like Momentum, but it does bring in a much lower spending threshold, which I think is about £30,000 in England. Then there are also constituency spending limits of £9,750 per constituency. This is obviously significantly higher than the RPA spending limit of £750 for a particular candidate in a particular constituency. And there's some ambiguity about how these two relate. One of the differences is obviously that the PPERA regulated period is a much longer time than the RPA regulated period, which is explicitly from the dissolution of Parliament. The other difference is that you might, for example, spend a huge amount of money on a billboard or a set of billboards in a particular constituency, which engages PPERA, but doesn't engage the RPA because it's not aimed at a particular candidate, but rather a particular set of issues. So, the next question you'll be asking is, what is regulated spending and how do I assess whether I'm doing it? I have to apologise now for the amount of detail which is on the next couple of slides, and in fact the whole presentation, but hopefully it will be useful for you to take away and think about after this webinar. When you're looking at whether your activities are PPERA regulated spending, there are 3 tests to apply. Taking the first one, the activity test, it's relatively straightforward because it's drafted so broadly. Spending on any of the following activities might be regulated under PPERA. They're on your screen now, but the key one to look at is the first one: material made available to the public by whatever means. This is incredibly broad and would cover a lot of your campaign materials. There's some question over whether website content would be regulated if you don't publicize it to the public in any way. But to be honest, you're probably not being a great campaigner if you put something out there and don't draw anyone's attention to it. The one important thing to bear in mind on the activity test is that it's not just the marginal cost or the additional out-of-pocket expense that you incur, but also associated staff time and other overheads. And the Electoral Commission guidance says that you should be reasonably apportioning a reasonable estimate of staff time and other overheads to your campaign spending. There are some useful exceptions, some of which are quite niche, such as translations from English to Welsh, but others which are really important and useful. So volunteer time. The Electoral Commission and the legislation recognise that volunteer time, although incredibly valuable to charities and non-party campaigners, does not have a financial value and does not count towards your spending limits. Once you've identified whether your campaign expenditure is incurred on an activity which is regulated, the next question is, does it meet the public test? Expenditure will generally not be regulated unless it is directed towards the public. Most of your campaign material probably will be directed to the public, but there are two quite useful limitations to this. Firstly, constitutional members are not the public. This might not be applicable to many organisations, but if you are a large-scale membership organisation, like for example the National Trust, then your communications with your members wouldn't be caught by PPERA. The Electoral Commission also considers committed supporters not to be the public. Unfortunately, it takes this phrase quite narrowly, as people who are regularly giving direct debits to the charity organisation or perhaps otherwise actively involved, so who regularly volunteer for you, for example. So if you're communicating with those people, they won't be the public. Unfortunately though, the Electoral Commission doesn't consider that people who follow you on Twitter, like your Facebook page, or have signed up for emails are committed supporters. Those people are probably still members of the public. If your activity and your campaign expenditure passes the activity tests and the public tests, then the next question is, does it pass the purpose test? Spending passes the purpose tests if it can reasonably be regarded as intended to promote or procure electoral success at any relevant election for political parties or political parties who advocate for particular policies, or, incredibly broadly, candidates who hold or do not hold particular opinions or advocate for or do not advocate for particular policies. So that could be anything from supporting a particular political party to encouraging people to vote on the basis of a particular policy which divides the parties or even divides candidates on a cross-party basis. The legislation also fleshes this out a little more and says that it's not just things which are supporting the election of particular parties or candidates, but also those which are prejudicing them. And your activity doesn't have to name a party or candidate or have the sole or main purpose of influencing voters in order to be regulated. The Electoral Commission has really helpful guidance which fleshes out the legislation even further, and it's just updated this. The guidance recognises that if your campaign doesn't mention candidates, parties or elections, your spending is much less likely to be regulated than otherwise. In order for an activity to meet the test, the voter needs to know which way they're being persuaded to vote. However, it is worth bearing in mind that just because you don't identify a party or candidates, you could still be carrying out regulated activity if you implicitly encourage voters to vote in a certain way. A good example of this is if a policy or issue is so closely or publicly associated with a party that you don't have to name them for voters to immediately recognise that you're asking them to vote in a particular way. The other thing to note is that Regardless of your intention, the test for the purpose test is whether your activity can reasonably be regarded as intended to do something. Therefore, even if your primary intention is actually to raise awareness of an issue, encourage people to register to vote, or some other purpose, if the Electoral Commission or someone complaining to the Electoral Commission considers that it can reasonably be regarded as intended to promote the success of particular candidates, then it will pass the purpose test. One thing that charities and campaigning bodies might be particularly conscious of is political parties adopting policies which you've been campaigning for. Obviously, on the one hand, that's a huge success. You've put time and resource into campaigning for an issue, and a political party who might form the next government have adopted it. But this does raise questions for the purpose test. Does, for example, the Labour Party adopting a particular policy mean that it's now a party political issue and your campaigning on it will be regulated? The Electoral Commission's guidance helpfully recognises that just because a party adopts a policy, that doesn't make your campaign regulated. If your campaign didn't meet the purpose test before the party adopted it, then it probably won't do afterwards. The exception to this is if you change your campaign strategy or your campaign spending because of the way the political party has adopted it. The Electoral Commission explicitly recognises that if a political party adopts your campaign position, you're probably going to want to welcome that and say, thank you to Party X for joining us in calling for our campaign goal. Ultimately, the Electoral Commission's guidance does distinguish between charities and other campaigners, and Douglas is going to touch on that a little more.
Thank you, Suhan. Yes, I am going to touch on it a bit because this is new in the Electoral Commission's guidance, and it is very welcome. So the Electoral Commission guidance now recognises that charities are bound by charity law, not to be partisan and not to be party political. And it also recognises, I should say, that some NGOs are also bound by their own rules, not to be partisan or party political. The guidance now expressly says, if you are a charity and abide by charity law and guidance from the relevant charity regulator, in most circumstances, your campaign activity is unlikely to meet the purpose test. So that means that charities should still consider A, whether they're spending enough on anything campaign related that in the regulated period that they might even potentially be in registration territory, and B, if they are, then thinking about the public and the purpose test to think about whether their activity meets it to decide how much might be regulated. But in the Electoral Commission's view, they are unlikely to be carrying out regulated activity at all.
On your screen now, there are just a couple of questions which can help you assess whether your campaigning meets the purpose test. So the key question, remember, is whether not what you intend, but whether a reasonable person would regard your campaign as intended to influence voter choice. The things the Electoral Commission suggests looking out for are the tone of your campaign, whether it's positive or negative to a particular party or issue, the context and timing, obviously over the next 6 weeks, the timing is key, and whether there's an explicit call to action. In fact, the call to action can also be implicit. Are you asking, explicitly or implicitly, voters to vote in a particular way?
So it's worth just emphasising that the purpose test in the new guidance is actually more helpful than it used to be. It's clearer, it's sharper, and it's therefore easier for charities to see when their activity is or is not likely to be regulated. So the first thing to say is that call to action is now more tightly defined than it used to be. The Commission is now referring specifically to a call to action to voters. Now, I know that charity campaigners and NGO campaigners would often have thought about call to action in a much broader way. The Electoral Commission always meant something rather narrower than that, and they're trying to make it much clearer now that this is about explicitly or implicitly encouraging voters to vote in a particular way. Second, the meaning of implicitly promoting parties or candidates is now clearer than it was. It refers in the guidance to setting out or comparing the merits of the positions of political parties or candidates on a policy, and not just listing the positions, which I think again makes it clearer that it's about giving voters a steer on the merits of parties or candidates, either explicitly or implicitly. And third, the guidance is clear about what happens, as Suhan said, if a party adopts a policy you've already been campaigning on. I won't repeat Suhan, but it is a it is a new thing, a new degree of emphasis, which is, I think, also very welcome and useful for charities.
So I'm sure that you've all been thinking about your own campaigns and how to apply the purpose tests over the past couple of weeks, but we thought it might be helpful to take a quick look at a couple of examples. This is an example from, I think, the 2015 election, although I'm not totally sure, the 2017 election, in fact. And it was a campaign, as you can see from the bottom there, from a number of organisations, including charities and corporates. Do you think this would pass the purpose test? Stacey?
I don't think it would, because I don't think it's actually asking voters, telling voters which way they should vote. It's more asking politicians what they should be doing.
Yeah, absolutely. And I think even to the extent that there was a call to voters, it's not along a particular policy issue or party. It's about a general approach to politics. Our next example is a campaign from Stonewall, again from the 2017 election. This is more clearly directly on particular issues. Stacey, what do you think?
Again, it's asking every party. It's not a call to for voters to vote a particular way.
Yeah, I think that's right. Where that might be slightly different is if Stonewall had, for example, set out the particular party's positions and ticked the ones that they agreed with and crossed the ones they didn't. That might be a bit trickier because it would make a judgment call about the parties and their policies. This last one, hopefully, is clear to you that it would actually pass the purpose test. It's very clearly asking voters to vote in a particular way. And as I'm sure you know, CND is not a charity and therefore wouldn't have been subject to charity law in this instance. So a quick recap. How can you avoid incurring controlled expenditure? That's expenditure which would be regulated under PPERA. You'd be looking to ensure that your expenditure does not pass the purpose test, does not pass the public test, so is only to, for example, politicians or your constitutional members, or is not a regulated activity. If you're looking to avoid incurring controlled expenditure, you might want to adapt your strategy. One thing to think about really carefully is your terminology and tone. If you're using hashtags that a particular party uses or its slogans, so for example, get Brexit done, or for the many, not the few, then that's obviously going to be aligned to a particular party. Something that's a bit trickier is where a phrase is particularly aligned to a particular party. The Electoral Commission cites the bedroom tax from 2015. Although you might think that that's clearly about a policy rather than any particular party, the Electoral Commission took the view that it was coined and used by the Conservatives' opponents and was therefore party political.
So we're about to start talking about working in a coalition and joint campaigning. And I think we'll have a quick poll at this point as well, because I am reliably informed that particularly a number of you who signed up via Bond are particularly interested in this area of work. So it should be up on your screen now, a chance to vote on whether you're doing any joint campaigning, working with charities in a coalition. So I'm reliably told this is quite a big area as far as Bond's concerned, isn't it, Stacey?
Absolutely. I think Bond members will be thinking about this for sure. We're fairly confident that what our work is doing together is going to won't be seen as joint working under the Act, but we're going to keep assessing this as we go through.
Okay. Yeah, so I'm sure it's something which a number of NCVO members will be thinking about as well in terms of sort of sectoral cooperation. I know that we've had some conversations about it as well. And looking, that's good. It's quite a relatively even split actually, but a clear majority feel they are doing some kind of joint campaigning or working. So we'll talk a bit about the rules and you know, both in terms of the general principle, but also in terms of people who choose to do lead campaigner and minor campaigner arrangements as well. So on that note, over to Suhan.
Great. So as you might be aware, joint campaigning can be a bit of a risk area and hit the headlines over the past couple of years after the EU referendum and the Electoral Commission's fines against Believe and Vote Leave for their joint working, which meant they exceeded the thresholds. The reason that joint working can be quite tricky is because if you are found to be joint working by the Electoral Commission, both parties have to account for the total spend of them together. So if, for example, you are a relatively small campaigner working with a much larger campaigner and you incur £100, whereas the larger campaign incurs £30,000, but they're both in the same campaign, then you both have to account for all of that spending. This means you both have to register and both have to deal with all of the administrative issues. There is a provision in the legislation for one of you to register as lead campaigner and the other to register as minor campaigner, but this can still be quite tricky to navigate. In order to assess whether you're working in a coalition or joint working, the Electoral Commission has some really helpful guidance. I won't go through this in detail now because I'm conscious of time, but the key thing to think about is whether you're making decisions together. And it's worth having a look at the guidance and the examples on this slide to think about whether or not you are joint working. If you do have to register with the Electoral Commission, either because of joint working or just because you as your organisation is going to be hitting the thresholds, you need to have detailed systems in place to authorise your spending. You need to keep your invoices over £200 and submit detailed reports to the Electoral Commission. There are also controls on donations. Donations under electoral law are only donations over £500, so they don't include small donations. It also is only relevant for donations which are specifically for your regulated activity. So if you're a charity, donations to your general charitable purposes aren't regulated. If you are receiving regulated donations, these can only be from permissible donors, which has a detailed definition, but basically excludes UK political parties, foreign entities, and non-UK people who aren't on the UK electoral roll. The final bit of detail to think about is imprints. This applies whether or not you are registered with the Electoral Commission, and the Electoral Commission can be quite hot on pursuing compliance. If you produce printed election material, then you need to include the name of the printer of the material, the person who's authorised the printing, and the organisation which that person represents. You can see an example on screen there.
Okay, thank you very much, Suhan, and over to Stacey for a little bit on compliance.
Thank you. Yes, and thanks, Douglas. I'm going to talk about compliance and the systems that we put in place at Bond. But first of all, I want to start off with some reassurance. These rules do seem really off-putting, but we shouldn't let this stop us from campaigning and speaking out for the interests that we represent. So just to enforce this point that our campaigning is perfectly legitimate, here are a couple of quotes from the Charity Commission and DCMS. Indeed, the new Electoral Commission guidance says that campaigning is part of a healthy democracy and the active participation of non-party campaigners should be encouraged. So at Bond, we have this great flowchart which outlines what you should do if you decide to register or not. The key point here is to involve your board and trustees and make sure that they understand and agree with your plans and have sign-off for the unlikely event that your campaigning comes into question. As has been said before, if you decide to register, make sure you nominate a responsible person and keep track of your spend. If you don't want to register, remember you can still campaign behind the scenes and talk to your committed supporters. But also remember you can still carry out regulated activity as long as you don't overspend. In either case, make sure everyone in your organisation knows the rules. So on the Bond website, we've got an example PowerPoint presentation that you can use to explain it to them. So I'm going to quickly cover off sign-off procedures and recording systems over the next couple of slides. So this is a simplified version of the sign-off procedure that we're using at Bond. Anything that can be defined as election campaigning material would be sent through to one named person, which unfortunately in this case is me. So I make a decision on if it's regulated or not. And if I'm not sure, I'll contact the Electoral Commission. And if the issue is borderline or I know it will be regulated, I'll get the sign off from our policy director. And then we put the decision into writing so that we can refer back to it if it's needed later on. And then we record it on the system that we'll just show you next. So we keep this recording system in Excel. So I've extracted some of the examples here for you. First, the activity log. We record if the activity is joint, if it meets either the public or purpose test, or if we think it's regulated. And then most importantly, the rationale for our decision. We've always understood that the Electoral Commission and Charity Commission like to see the working out. And then second, we also record the staff and non-staff costs to monitor the spend to see if they get anywhere near the limits. These can be quite fiddly, especially if you're thinking about the cost of Twitter. So if you do register, this is the sort of data you'll need to supply to the Electoral Commission. And if you haven't, it's good to have that for monitoring spend. But you might decide it's overkill, as there's no need to do this if you won't get anywhere near the threshold. So for more detailed advice on this and some more guides and templates, head over to the Bond's website.
Thank you, Stacey. So we're now just about to go into questions, and we'll try and answer as many as possible. If you'll forgive me for eating into a little bit of time, I should just say that both this webinar and the PowerPoint will be available to look at and ponder at your leisure afterwards, because I know that it's been quite a kind of information-rich session. So we'll try and get through as many questions as we can. So to take one, start from the top, I think. So one here is, if one party publishes something relevant to your charity in their manifesto, but other parties don't, can you publicise this? It's in the interest of supporters to know about it, but could it look like you're promoting that one party? So I think there's some quite sort of specific stuff in the guidance around some of this sort of stuff, isn't there, Suhan?
Yeah, absolutely. So that can be quite a tricky issue, so it's a good question. I think if you were to compare the parties' policies to your own, that may well amount to regulated activity. That doesn't necessarily mean that you can't do it. It just means that you have to think about the spending limits and whether you would need to register and start recording all of your spending in detail. If your budget is quite small, then you might need to think about charity law if you're from a charity, but you can still probably do that. But there is a chance, I think, that depending on the way you do it, could amount to regulated activity.
I guess it's just worth thinking about that point in the guidance around saying that if a party adopts your policy, then carrying on with the campaign that you're carrying on with does not in and of itself pass the test as well in terms of how you do it.
Absolutely.
I guess just so long as you don't make your activity more pronounced following that.
Yeah. Okay, so next one, short one. Is the Brexit Party deemed to be a main political party for the 2019 election?
Again, a very sharp question. So my views on that would be that yes, it is. I think although it's not standing in every seat and although it doesn't currently have any MPs, it is a major party in the debate. And although, for example, if you were organising a local hustings or campaigning on a local issue where the Brexit Party wasn't standing, then that's a perfectly reasonable and objective way for not including them in your activity. If you're doing something at a national level, they are a major political player, notwithstanding that they don't have any parliamentary seats yet.
Yeah, I mean, I think for what it's worth, that will be our instinct as well. It's worth noting that if you're thinking specifically about hustings, there is specific guidance available from the Electoral Commission around what is a selective or a non-selective hustings. And the rule of thumb is having either inviting all candidates to a local hustings or having impartial reasons that you can evidence for not including, if you want it to be non-selective rather than selective hustings.
And just to add to that, an impartial reason might be, for example, that a particular party or candidate had run at the previous election and lost their deposits, and therefore you don't think is particularly relevant. I think that argument, though, would struggle for the Brexit Party, given that they're a new party and their what you might consider predecessors have previously been relatively successful.
Okay. So next question then. Does Views My Own actually exonerate people from party political things if it's really clear they work for the charity?
Stacey, any views?
Well, certainly we've said in Bond to get people to take away the Bond tag from their online for Twitter and Facebook. I think it's tricky when you've got your senior members of the organisation and they're involved in the party. I think in that sort of situation, you'd probably have to have conversations with your board and trustees as to the impact that this could have. So it's a tricky, it depends on what level you are and how much people associate you to your particular charity.
Yeah, I would definitely agree. I think it's, even if it's obvious that someone works for the charity, what you really need to be thinking about is whether the public might perceive them as representing the charity. And that's where Views My Own does, I think, help quite a lot, particularly for junior members of staff or volunteers. But exactly as Stacey said, if you've got the chief exec or something of a charity who says Views My Own, but in the public's eye, they're very much one and the same as the organisation, the voice of the organisation, then for those people, you might want a slightly more involved social media policy.
So, in summary, think about separation and seniority.
Absolutely.
Quick one here. So, is PPERA and the Lobbying Act the same thing? Perfectly reasonable question. The short answer is that the Lobbying Act amended PPERA. PPERA is the overall framework of electoral law for general campaigns. The Lobbying Act brought in a number of changes to PPERA. But because the Lobbying Act made the issue much more prominent in the minds of lots of charity campaigners, people often talk about the Lobbying Act colloquially.
Exactly. The one thing I would add to that is that the Lobbying Act also brings in various obligations for consultant lobbyists and people paying consultant lobbyists. And while that won't often be relevant for charities and campaigners, it could well be. But generally, I think in the sector, when people talk about the Lobbying Act, they will be talking about PPERA as amended by the Lobbying Act.
Okay. Next one. What is regulated activity?
A less simple question there.
Yeah,
So,
but key.
Yeah, exactly. When you're looking at what is regulated activity, you need to go back to those three tests, whether your activity is regulated under PPERA, one of the types of activity which is regulated under PPERA, which is really broad and basically is anything which is going to the public with a couple of exceptions. Whether it goes to the public is the next question. And then finally, whether it meets the purpose test.
Yeah, I think the kind of that's how to work it out. I think it's worth saying essentially regulated activity means activity that would count towards limits under electoral law. So if it doesn't count in any way towards potential spending limits with the Electoral Commission, then it wouldn't be regulated activity. If it does, then it is.
Yeah.
Okay. So having a look now. Next one, if before an election we had two campaigns where we thanked two individual MPs specifically for their support and there are tweets about that individual on our account, do they need to be removed?
That's interesting. I suppose it would depend on what the issue is and what parties those MPs are from. But I think the Electoral Commission's new guidance is really helpful on this point. Mm-hmm. So the Electoral Commission recognises that you may well welcome a party for their support, and I think that reads across to particular MPs. It's totally normal that if you've been campaigning on something for a long time, you then want to say, you know, we're really glad that the MP for X has joined us on this.
I mean, to me, Stacey, I don't know if this is your view as well, but it was my instinct. Obviously, we haven't got the full details here, but my instinct would be that we're talking about campaign activity intended to get as wide a range of supporters as possible to sign up to a campaign before an election was formally announced in the context of trying to get a policy adopted. And I think between the Electoral Commission's new guidance and between the overall purpose here being to secure a wider range of support potentially from all parties, I would doubt that you'll be in purpose test territory very much.
Yeah.
Yeah, I totally agree with that. It'd be interesting to know if that was the same situation had we known the election was going to be happening. But that's a conversation for another time.
Okay. Another one. What was an interesting one? Do you think it's okay to engage with Welsh AMs, for example, during a general election, just in case Assembly members?
So I think it's important to remember that the Lobbying Act doesn't prohibit engaging with politicians, and in fact your activities engaging with politicians may well not pass the public test of regulated activity if you're campaigning them to pull up issues in their manifestos or adopt a particular policy. However, what is really important to think about is charity law if you're from a registered charity. While activities to Welsh Assembly members or people who have been members of Parliament and which isn't public wouldn't be regulated under PPERA, you would have to think about your independence as a charity and whether you are favouring one particular party or seen as siding with one particular party. And for that reason, as a general rule, it's probably best to be, if you're a charity, campaigning particular parties and politicians across the spectrum and trying to engage them all, even if you're actually really aware that a particular party won't be adopting your policy.
Yeah. So it's not so much a case of yes you can, no you can't. It's more a question of apply the same principles on charity and if necessary electoral law that you otherwise would.
Yeah.
Is that fair?
Yeah, absolutely.
Okay. So I've got one here on joint campaigning. The question is, I run a coalition and I have a couple of concerned members who are worried that spending by any one member can be counted against their spending. If I feel that what the coalition is doing jointly during the general election, some of which I feel meets the purpose test, is this enough as reassurance? I suppose this is a question here around kind of what counts as joint campaigning and what doesn't, I suppose.
Yes, exactly. So one thing I would suggest is taking a look at the guidance and thinking about whether your campaign is truly a joint campaign and everyone's in the driving seat to a relatively equal measure, or whether actually it's a campaign run by one organisation that other organisations are adding their voice to and supporting. And you might do that by adding your branding to the website, signing joint letters, but you're not actually driving the conversation.
Okay, and I think I guess as that's sort of, I know when I've heard the Electoral Commission, they often talk about that. They very much emphasise that phrase, making an honest and reasonable assessment of whether you are working to a common plan or arrangement.
Yes,
that's
absolutely.
the kind of lodestar, I suppose, that they often cite. I think that's fine. Okay, so next one. Can you unregister again if during the campaign you realise you won't spend as much as anticipated?
That is a really good question, and I do not think that you are able to do that, but
you'd probably be able to put in a nil return to
yes,
the commission when you sent back your compliance forms.
Exactly.
Yeah, that was what I understood as well. It's a good question. Does material on your website designed for your active supporters pass the public test? It's publicly available, but only intended for supporters.
That's quite a tricky one, I think, and it would depend on how you promoted that information. And I think probably, obviously I haven't had sight of the material or how it works, but a conservative view would be that yes, it may well count as public because it is accessible by the public. I did touch on that issue of there was a slight question over whether website content is public if you're not promoting it anywhere. But I think the thing is that you probably will be promoting your website at least in ways that are public facing, and unless that material is behind a login page or otherwise prohibited, there's at least a risk that someone might perceive that to be public.
Okay. Next one. Can supporting PPC's prospective parliamentary candidates to place media at any costs incurred to do this be regulated activity?
That's interesting. So I think there's a couple of things to think about there. The first one is whether you're actually engaging the Representation of the People Act, which is, the £750 prohibition that we dismissed quite early on. But that's about whether you are actually doing something which is intended to procure or promote the success of a particular candidate, and supporting a PPC by placing them with public media slots could well be regulated under that piece of legislation. Then whether it's regulated activity for PPERA will, I think, depend on exactly what you're doing and how you're doing it, which I know isn't particularly helpful. But you do have all of our contact details in the slide deck if you want to get in touch and chat through that in a bit more detail. I'm not, I don't want to confuse things by giving a really general answer to that one.
Yeah, and I think there's a common theme here around applying the same principles to cases on a case-by-case basis, isn't there?
Yes, absolutely.
So a final question. We've managed to get most of the questions, but I apologise to the couple of you who we haven't managed to cover off. Can we retweet candidates who sign our pledge and tweet support?
So this is a really tricky question. I'll be grateful for your views before I jump in.
I'd possibly say it was regulated, but it'd be such a small amount of money you'd be spending that it wouldn't perhaps contribute too much to your overall spend.
I think my view in practice would be that before I got too intensely engaged in the question of whether the individual tweet or retweet is regulated activity and therefore what I need to report to the Electoral Commission and so on and so forth, I think I would start with the question of, am I anywhere near the spending limits in practice in the first place? I think it's an interesting one because it kind of plays into that question, doesn't it, of welcoming support. And I suppose welcoming support from a candidate is in principle not different to welcoming support from a party.
Yeah.
And so I suppose essentially the same general questions around the difference between carrying on with essentially what you were doing already versus stepping up your campaign, and the question of where that line is probably applies here, I think.
Yeah, absolutely. I definitely agree with all of that. And I think the Electoral Commission's guidance, because of that point about welcoming, is really helpful and suggests that a kind of pledge campaign in that manner might not be regulated activity, but it would really depend on how you do it and how you frame the pledge question and how you interact with the politicians. The charity law guidance is a bit more ambivalent, so I think pledge campaigns can be a really tricky area and would depend on a number of factors, such as how politicised the issue is, how much money you put into it, and that kind of thing. So sorry not to have a really clear answer on that one.
But on that highly nuanced note, thank you very much to everyone. I'm sorry we couldn't take quite all your questions, but I do hope this was useful. And when the PowerPoint's made available, you will see our contact details. But I'm going to briefly pause on each one so you can see them now as well. So on that note, thank you very much to everyone, and thank you for attending. I hope it's been useful, and all of us are certainly very happy to hear from you about further questions or anything else. And have a good rest of your afternoon.